Good morning and welcome to our panel, A Century of Abolition Under International Law. We are joined today by a fantastic panel made up of international law experts, Dr. Adejoké Babington-Ashaye, Dean Karen Bravo, and Professor Patricia Sellers. This panel is sponsored by BASIL, the Black Advocates of the American Society of International Law. In terms of introductions, Dr. Adejoké Babington-Ashaye is an international lawyer with experience in public international law, human rights, international criminal law, and the judicial settlement of disputes. She is actively engaged in the provision of technical support and training for national prosecution and investigation of international crimes. She is a former senior counsel at the World Bank and has worked at the International Court of Justice on the settlement of state disputes at the International Criminal Court as an investigator. She is the co-editor and author of International Criminal Investigations, Law and Practice. We are also joined by Dean Karen Bravo, who is the 13th Dean of the Indiana University Robert H. McKinney School of Law. Dean Bravo is an international law scholar and expert in the study of human trafficking. Dean Bravo is the founder and leader of the Slavery Past, Present, and Future Project, which organizes an annual interdisciplinary conference that brings together scholars, civic leaders, government actors, and other interested parties for a multidisciplinary exploration of human trafficking and slavery. And last but not least, we are joined by Professor Patricia Sellers, who is an international criminal attorney and the former special advisor for slavery crimes for the Office of the Prosecutor, the International Criminal Court, where she also served as the former special advisor for gender. Professor Sellers lectures on international criminal law as part of the Master of Human Rights Program Law faculty at Oxford University, where she is a fellow at Kellogg College. She has also served as the special advisor to the UN High Commissioner for Human Rights and to the UN Secretary General's Special Representative for Children in Armed Conflict. She also served as the legal advisor for gender-related crimes and senior acting trial attorney in the Office of the Prosecutor for the International Criminal Tribunals of the former Yugoslavia and Rwanda. She has litigated and advised on the leading international criminal law cases regarding wartime sexual violence and genocide, and sexual violence and enslavement as a crime against humanity. By way of a brief introduction to today's panel, the 1926 Convention to Suppress the Slave Trade and Slavery was the first global treaty on the abolition of slavery, and it was completed and first signed under the auspices of the League of Nations in September 1926, hence the centennial that we are recognizing today. Our panelists will reflect on this centennial of the passage of this global treaty and the importance and role of international law in suppressing past and modern forms of slavery. It's important to note, as you'll hear from the panelists, that in addition to international law, it was actually social justice movements, slave rebellions, abolition movements, and revolutions such as those seen in Haiti, and wars, such as the Civil War seen in the United States, that played a foundational role in bringing about the end of slavery in domestic contexts. And international law did play a role in supporting abolition, but it's always important to recognize the individuals and movements that led the ending of what is known as the transatlantic slave trade and the forms of slavery that resulted from that trade. Today, it's important to recognize that those movements were part of a catalyst for the broader 1926 convention that we are recognizing today. So I would first like to turn to Dean Bravo to help set the stage for us by reflecting on the role of these historic abolition movements in advocating for international legal mechanisms as tools to suppress the transatlantic slave trade and slavery.
Good morning, everyone, and thank you, Darin, and thank you, BASIL. I just want to recognize the work that you've done to put this panel together, and that it is a really significant 100th anniversary. I'm now going to foreground my response by celebrating a little bit the 1926 convention. That is, we're lawyers and we like language, so I'm going to talk a little bit about the language, right? It is the first international definition of slavery and of the slave trade, and defines slavery as follows. Slavery is the status or condition of a person over whom any or all of the powers attaching to the right of ownership are exercised. So very much grounding on ownership, as in based on chattel slavery, which we probably will talk about. Maybe slavery has evolved over time, or different aspects need to be recognized. The slave trade is also defined, and in defining the slave trade, we're going beyond looking at the ships coming across the Atlantic to different aspects of how an individual is enslaved. So the slave trade includes all acts involved in the capture, acquisition, or disposal of a person with intent to reduce him to slavery. All acts involved in the acquisition of a slave with a view to selling or exchanging him. All acts of disposal by sale or exchange of a slave acquired with a view to being sold or exchanged, and in general, every act of trade or transport in slaves. So every action along the way is the slave trade, not only thinking of going across the ocean in ships. In addition, here the parties undertake to address slavery, to do something about it, to suppress it. So the high contracting parties undertake with respect to all areas under their jurisdiction, their protection, their tutelage, so far as they have not already taken the necessary steps to prevent and suppress the slave trade and to bring about progressively and as soon as possible. That's a little bit of an out, the complete abolition of slavery in all its forms. So let's talk about a bit the context, which is the global nature of slavery and its omnipresence in human culture in time and space, across the globe, across time. So we're talking about enslavement of individuals and groups, not only in the transatlantic slave trade era. Africans were being traded to the Middle East and other countries as well, not only across the ocean to the quote unquote New World. But what was it about the transatlantic slave trade and the enslavement of Africans in the Americas and in Europe that led to the international legal mechanisms against slavery that we now see the progeny in our time, starting with, of course, the Slavery Convention? So abolitionist movements, including resistance by the enslaved themselves, rebellions, small and large, as well as these stories, the narratives, were all part of the abolitionist movement, but they didn't succeed in a vacuum. We need to situate that success in fighting against the slave trade within the Industrial Revolution and within the impact of colonization, that is, the huge power, the expansive power of European countries throughout the globe at that time. So the historic abolition movements played a pivotal role in advocating for international legal mechanisms to suppress the transatlantic slave trade and slavery. Early efforts often focused on persuasion and religious arguments, but as the movements gained momentum, abolitionists recognized that they needed action across borders to effectively combat the very deeply entrenched practices. So there was a great deal of interaction between abolitionists in the United States and abolitionists in the UK, for example. We can't underestimate the impact of Frederick Douglass's stay in the UK when he was escaping the possibility of being recaptured and taken down south. The consistent resistance of the enslaved played a key role, as did the transformation of economic and political structures. So speaking of the impact of resistance, things such as the Haitian Revolution and its impact, Nat Turner's rebellion in the United States and its impact. Tacky's Revolt and the Sam Sharp Rebellion in Jamaica, and all the acts of resistance counted toward abolitionism because they were reported in papers. People wrote letters, and there was a great deal then of cultural impact and social impact. And then let's talk about the Industrial Revolution and maybe why there was fertile ground in Britain for abolitionism. With the rise of capitalism and the impact of capitalism on the workers in Britain, which was the first rapidly industrialized country, those workers began to see a relationship between their dehumanization and disregard and the dehumanization and disregard of the enslaved people. So the resonance of the mantra, am I not a friend and a brother, a man and a brother, for example, that resonated because the white working class in the UK were now being displaced from the estates where they formerly had been and had rights. They were being moved into factories. Their children were also doing child labor. And so there was also a destruction of small-scale enterprises such as weaving, which had been really within the purview of small farmers, small capitalists, but now was being industrialized into factories. So those movements helped the abolitionist movement. It was not only leaders and elites talking about slavery and enslavement and its impacts, but then it was also being felt. So shifting from the moral arguments to legal action, abolitionists such as Wilberforce and his predecessors in the UK, as well as abolitionists in the US, where we can think of Garrison, Harriet Beecher Stowe, Frederick Douglass, primarily used moral and religious arguments to highlight the inhumanity of slavery. But when we marry that with the economic forces that then were being unleashed and the cultural differences that then took place as workers were moved into factories and towns, it then made that an economic and social issue. So this realization helped to propel advocacy into international treaties as well. So diplomatic pressures and treaty negotiations, once the British abolitionists had successfully advocated for the abolition of the slave trade in British territories, they also then exerted significant pressure on their respective governments to engage in diplomatic efforts. And so Britain abolished its slave trade. They then began to influence and negotiate with other European countries, entering into bilateral treaties with those countries and beginning to spin a web of anti-slave trade treaties throughout Europe. But not only that, they enforced, right, with the naval patrols like the West Africa Squadron, which intercepted slave trips, slave ships, whether on the coast of Africa, all the way into across the Atlantic in the Caribbean and across the along the coast of South America as well, so that ships carrying enslaved persons were intercepted and the folks rescued. I will note, however, they weren't rescued and sent back home. They would have been sent to places like Jamaica because some of them were, right? They were rescued from enslavement there, but then not returned to their homelands. But the impact of the British government and the British Navy running these patrols cannot be underestimated because it harassed the private actors, but it also stimulated conversations with other European entities, so that bilateral treaties were also executed there, granting reciprocal rights. I mean, what gives you the right, Britain, to board my ships? Okay, I'm going to have a right to board your ships as well. And so beginning to create transnational enforcement in that regard. And then with respect to establishing international norms and condemnations, we're all familiar with the Congress of Vienna, 1815, dividing the African continent among the European powers. That instrument also, however, produced a landmark declaration condemning the transatlantic slave trade as, quote, repugnant to the principles of humanity and universal morality. So you see, bringing that language into international documents. And that marked the first major international condemnation of the trade. Of course, it was not binding, but it's beginning to build that customary law. The inclusion of that language was a direct result of pressure by abolitionists in the UK on their own negotiator to make sure that the anti-slave trade success that they'd had abolishing the British slave trade would then be reflected in this instrument. Note that's 1815, so we haven't got yet to the time of the abolition of slavery by the British. That's 1834, sending them into a period of apprenticeship, and then 1838, where it is completely abolished. So that's the context leading up to or getting to 1815. Then there are some additional instruments, such as the General Act of the Brussels Conference, that's 1889 to 1890, Berlin Conference, 1885, and let's not forget the impact of the white slave trade panic, right? The white slave trade panic emerged in early 20th century, where there was this idea that white women were being seduced, tricked, and being sent to barbarous countries, right, to become sex slaves. And so this created really an international panic in the public, both in Europe and in America, leading to international agreements. So the International Agreement for the Suppression of White Slave Traffic was a 1904 instrument. Then the International Convention for the Suppression of the White Slave Traffic again in 1910. These and the International Convention on the Suppression of the Traffic in Women and Children all meant to then see the commonality. Is it a commonality if you say white? But some kind of thing between slavery and what they saw as the exploitation of European women. And these are some of the precursor instruments that lead us then to the 1926 Slavery Convention. And so I will end there. Thank you. I've probably exceeded my 10 minutes. Apologies.
Dean Bravo, no apologies necessary. That was a wonderful foregrounding. I do have just one brief follow-up before we move to our next presentation. Thank you so much for walking us through some of the predecessor international legal instruments that led to the 1926 convention. One of the predecessor instruments that you mentioned was the 1890 General Act coming out of the Brussels Conference. One of the criticisms, perhaps, of that act, which I think is consistent with some of the contradictions that were laid out in your presentation, is the motivations, right? The motivations of those states who entered into that agreement. I think one of the criticisms that some have lobbed against perhaps the UK and others who were quite active in suppressing the slave trade was that there were motivations beyond simply moral motivations, but actually that these instruments also laid and created a justification for further colonialism, right, and further movement into the continent. I wonder if you could reflect on, some of these contradictions, during this period.
Thanks, Darin. And that is absolutely correct, because even at the time where these instruments are being negotiated, it is a time of European expansion and entrenchment in the continent, so that articulating anti-slavery was not about the morals. It was about the economics, and it was about domination. And so being able to point to, well, look at us, we are entering into these anti-slavery instruments. We are making efforts in our previous activities, but at the same time, the people of the continent, the peoples, they are still engaging in enslavement, whether of each other or of other tribes. But the irony of this also is, even at the same time, the European powers were engaging in forced labor practices of African people, to whether to build the roads or other infrastructure, even as they were condemning the cultural practices in Africa. And I'm by no means saying I approve of one or the other, right? I'm not normatively defending either. Enslavement in whatever form is repugnant, echoing that language, and at that point had not yet been articulated as a crime. But it's it's the irony of it all. On the one hand, it helps to build customary international law by articulating the language, but understanding that it's in part an exercise of power in order to condemn practices, doing it yourself at the same time, but also facilitating your ability to co-opt those resources.
Thank you very much, Dean Bravo. And let me take a moment to speak to our viewers today. I know there are many watching, including students of ours, and I would encourage all of you to use the Q&A button to place any questions that you might have that arise from our panelists' comments. We would now like to turn to Professor Patricia Sellers. Professor Sellers, in your 2023 Goler T. Butcher Lecture at the American Society of International Law, you stated that today's distorted knowledge of African descendant enslavement has caused an erasure and diminution of the legal power of slavery and the slave trade as international crimes. Could you take a moment to discuss that contextual proposition for our viewers?
Right. Thank you very much, first of all, Basil, for organizing this webinar. And I, in particularly, want to thank you for this question, because this is a bit of a contentious question, I believe, among academics and practitioners. A legal scholar said to me after we produced the slavery crimes policy at the International Criminal Court, that finally we have some context to the text, meaning that black letter law does not just drop out of the sky. It comes in a context. And the definition of slavery from the 1926 Slavery Convention, and I have to say that it's the same definition that you find in the 1956 Supplementary Slavery Convention, has a context. First of all, I'd like to give a shout out not only to the 100 years of the 1926 Convention, but the 1956 Convention is also 70 years old. I mean, together, one has to at least acknowledge that these are some of the oldest or long-standing treaty body conventions, black letter law, peremptory norms that guide the international legal framework. Well, getting back to my response, that those two treaties outlawed the de jure, or the legal ownership that could be enforced, such as by contract or a court order, chattel slavery, the ability to really own someone else legally. But what's important is that those two treaties took the further step, and they outlawed the de facto ownership of a person that might have been reliant on cultural practices or even social conventions or an ad hoc situation. When you think of hereditary slavery today, and we understand that it often occurs outside of the realm of du jour, we know that these conventions outlawed all the de facto practices as well. The definition of slavery that I'm very happy that Dean Bravo went over relates to the exercise of powers of ownership, exercise of powers attaching to the rights of ownership. And as I said, it has a historical origin, and that is the chattel slavery, not only of the Caribbean, North and South America, but also the East African slave trade, and to another extent, the slave trade within the Mediterranean that I think we understood as the Barbary trade that was held in the 1770s. I'd like to get back to a little historical anecdote regarding that trade later on. But the historical origins of this definition, exercise of powers attaching to the rights of ownership, has to be understood by academics and practitioners as to legally meaning something. So how do you exercise powers of ownership over someone? Well, if you do not go back and look at the historical facts around this definition, you no longer can really apply the definition as a legal standard. So, for example, we readily want to look back at the agricultural labor and the cotton or the tobacco field on the waterfront, in factories, or in private homes, or in churches, or in universities. The enslaved had powers of ownership exercised over them everywhere, including sexually, their reproductive capacity, ability to practice their religion, to choose their spouses, to raise their children, to travel, and I would say, et cetera, and et cetera. If exercise of powers attaching to the right of ownership, de jure and de facto, but today, we cannot use the slavery conventions as the black letter law, as the outlawing that was intended. Ignorance of the factual history of the African descent slavery in the Caribbean, pardon me, in North and South America, really constrain our legal interpretation and constrain the interpretation that now we look at slavery committed by Daesh or ISIS, excuse me, such as the sexualized enslavement of the Yazidi or the industrial slave labor policies of the Nazi regime. I'm going to have to take a break because I'm going to break into coughing. Could we move on?
Please take a moment. Perhaps what we can do is engage in a bit of reflection for a moment about some of the concepts that Professor Sellers has shared, including the idea that the transatlantic slave trade, the form of chattel slavery that many of us are familiar with in the United States, is not the only form of slavery that actually would be captured by the conventions. Professor Sellers, I see that you're back, so I will return to you unless you need a moment.
Thank you for raising that point. I will try to persevere, but I will probably
thank you so much.
My remarks a bit, because I wanted to make the very same point on the slave trade. And as Dean Bravo mentioned, we think of the transatlantic slave trade, and there were hundreds and hundreds of ships that came across. But there were millions of non-transatlantic slave trading that was done internally, the domestic slave trade, whether people were inherited, whether people were given as gifts, whether people were traded, held against debts. The slave trading, when it was abolished in 1807 by the British, actually caused the internal or domestic slave trade to grow. And people started procreating slaves, moving them from Maryland, Virginia to New Orleans. So the millions of acts of internal slave trading are also covered by the definition of the 1926 and the 1956 convention. And that is where not only you reduce someone to enslavement, but that you dispose of, sale, transfer, or transport of the already enslaved. So to summarize, I just want to say that the convention refers to kidnapping and capture, reducing to slavery, but also how many times were the enslaved then internally slave traded? The only person who probably wasn't slave traded originally is that person born into slavery. When academics and lawyers ignore the breadth of facts that come under the definition of the slave trade as in slavery, we limit our ability to look at, for example, the child soldier, who is basically an enslaved child. And every time that child is reposted to a new battalion, that's an act of internal slave trading. When we don't understand that girls and women who have been placed in sexualized enslavement, let's say by Joseph Kony, every time they're switched to a new fighter, that's an act of internal slave trading. So our ignorance of history of the Americas and the Caribbean lead us to be willfully blind as practitioners and academics and activists about slavery and the slave trade. I will stop here before breaking into a cough.
Thank you so much, Professor Sellers. We will absolutely circle back to you with some follow-up questions. But I think at this moment, we can turn to our third panelist, Dr. Babington-Ashaye. So Dr. Babington-Ashaye, along with Professor Sellers, you were the co-drafter of a resolution ultimately adopted by ASIL at its 2025 annual meeting. The resolution expressly restates accepted international law that slavery and the slave trade are violations of non-derogable human rights and can constitute international crimes, including crimes against humanity and war crimes, that the prohibition of slavery and the slave trade are peremptory norms from which no derogation is possible, and that the protection from slavery and the slave trade is an obligation erga omnes. Could you take a moment to discuss the goals and objectives of that resolution, particularly in light of action within the ICC Assembly of State Parties and the United Nations on both the revisions to the Rome Statute and the Draft Crimes Against Humanity Treaty?
Okay, awesome. Thank you so much, Darin. Thank you to BASIL. Thank you to ASIL for organizing this. And I'm so honored to be part of this very important conversation. And let me start then with the core of the ASIL resolution, which I really must say is the brainchild, Patty's brainchild. And we also co-drafted an Insights article. I will drop the link to that in the chat for those who may not have had a chance to read it yet. And in there, we noted that the purpose of resolution is to enunciate a foremost peremptory norm of international law that merits contemporary acknowledgement and reiteration by the society. So that's just a little sentence in the article. I'm going to break it down. Our goal essentially with the resolution was threefold. First, to speak into a very specific historical moment. ASIL voted on this resolution at the same time that the international community was moving forward on two major fronts. As you've mentioned already, the proposed amendments to the Rome Statute of the ICC to explicitly enumerate slave trade as a crime against humanity and to recognize slavery and the slave trade as war crimes. So there's work being done in that respect. And then also the negotiation of the first Crimes Against Humanity Treaty at the United Nations. And the Crimes Against Humanity Treaty, as developed by the International Law Commission, it includes a provision to enumerate the slave trade as a crime against humanity. And that provision has gained, widespread support, and it's meant to reinforce essentially the direction that was set by the 1926 Slavery Convention and 1956 Supplementary Convention. So all of these matter, as I mentioned, also the Rome Statute, the work being done on the Rome Statute. All of these matter because one of the really actually interesting article that people should also read is another piece that Patty has written, where she argues that there are salient legal differences between slavery, the slave trade, human trafficking, even if there may be factual overlaps. And the failure to clearly enumerate these in, key instruments such as the Rome Statute and, of course, the Crimes Against Humanity Treaty that's coming out, the failure to address them, the distinct nature of these crimes, and instead to treat them as one undifferentiated category, we end up risking under capturing the specific wrong that has occurred with slavery and with the slave trade and the other forms of responsibility that it entails. And so to that end, then the ASIL resolution was not just symbolic, it was supporting and amplifying these concrete legal reform efforts by essentially stating in the voice of a leading professional society what is already stated, in 1926 convention, which is that slavery and slave trade are peremptory norms. Their prohibition must be fully reflected and thus reflected in other aspects, such as in the Rome Statute and in the Crimes Against Humanity Treaty. So another key goal really is that the resolution is also about ASIL and its historical role and its own position. So ASIL has long described itself and its mission as fostering the study of international law and promoting international relations based on law and justice. And as we acknowledge in the Insight piece, however, there was a notable silence in ASIL's own publications on the 1926 Slavery Convention, the 1956 Supplementary Convention, and related provisions in core human rights instruments. And that silence was part of a broader legacy that ASIL itself has sought to address in various forms. We do, of course, have the Richardson Report. So many different activities have been done in that light. So by adopting this resolution, ASIL was both correcting an internal omission and also making a very valuable external statement, which is beneficial to international community, especially at this pivotal time where there's work being done to address the legal lacuna concerning slavery and the slave trade. So externally, it's signaling to states, the international organizations, courts, that the society affirms that peremptory character of these prohibitions and supports their full and explicit codification. And let me also then briefly connect this to the wider political and repertory context, particularly in African Caribbean, as has been discussed briefly. We're seeing a coordinated push by the African Union, by CARICOM, to address the legacies of slavery and the slave trade through reparatory justice and accountability. Last September, there was an Africa CARICOM summit under the theme of Transcontinental Partnership in Pursuit of Reparatory Justice for Africans and People of African Descent through Reparations. And it's explicitly framing slavery and slave trade as foundational injustices that require not just legal redress, but also political and economic. The African Union has also declared 2026 to 2035 as the decade of action on reparations and African heritage, underscoring the urgency and importance of this global conversation. And then also we do have a declaration which will be introduced by Ghana at the General Assembly on Slavery and the Slave Trade of Africans. So in that sense, the ASIL resolution sits within a broader ecosystem of initiatives. And that's why I'm so proud of the society for taking this very important step that they took last year to adopt the resolution. And the broader ecosystem of initiatives, whether it's legal, political, moral, these are all converging at the same point where we're talking about, especially when we're talking about transatlantic chattel enslavement of Africans, we're not only thinking about it in the historical context, but also in ongoing legal implications of them. And so I will stop there and look forward to the discussion.
Thank you so much, Dr. Babington-Ashaye. That context is so important regarding what is happening at this current moment, right, to continue the legacy of using international legal mechanisms to combat modern forms, right, and rather ongoing forms of enslavement and slavery and the slave trade that we have seen continue to occur. So perhaps this is the ideal moment to turn to each of our panelists and to ask for your thoughts on the forms of modern enslavement that we think have perhaps been undercaptured, as Dr. Babington-Ashaye has noted, and as Professor Sellers and Dean Bravo have noted in their work, and what additional efforts could be undertaken to ensure that these modern forms of the slave trade and enslavement are fully addressed. So perhaps I could turn to Professor Sellers initially.
Thank you very much, Darin. Well, I'm going to, as a matter of fact, give us an example, one that is not very often used. And I want you to really think about it. We recently heard about the Syrian detention centers, where some people disappear for years and are shifted around to different detention centers. And we do know from the Latin American experience of enforced disappearances that people can go into a detention center, end up having been killed or released years ago, and their children given away to different people. So I question, in these detention centers, is someone exercising powers of ownership over the detainees? If we were to understand, what does it mean to be enslaved? What if it were interior? And when people are shifted to different detention centers, are those forms of slave trading detainees? Now, the reason I absolutely throw that out there is to loosen our mind and to realize actually the profound legacy of these slavery conventions built upon the African diaspora and African experience. So that's an example I'd like to offer.
Thank you very much, Professor Sellers. Dean Bravo, would you like to comment?
Thank you much, Darin. And I think I'll piggyback a little bit off of Professor Sellers' comment. The question of modern forms of slavery is very pertinent and has garnered a lot of attention around the world, starting with the Convention Against Transnational Organized Crime and the optional protocol regarding trafficking in women and children. It was very much focused on the question of transnational organized crime. So the transnational nature of it, not the internal aspect of what happens internally. And it also was not focused on states. So one of the questions I've asked, what is the role of a state in modern forms of slavery? Even if we look at our 13th Amendment, there's an exception, right? In prohibiting slavery, there's an exception, a huge, what I would call a Mack truck exception, because the exception is for a crime for which you will have been duly convicted. And duly convicted, I guess duly we could hang our hats on, that it wasn't a false conviction. But how do we think of people who are imprisoned, who are convicted, imprisoned, their labor exploited, so that we have prison labor and we have profit making based on that labor? But perhaps even worse, there's profit making based on just the very fact that these people are contained in a carceral system creates profit. So just by being alive and imprisoned, they're being exploited. Is that a form of modern day slavery that we should be thinking about? And then thanks, Patty, for, you're moving them from one prison to the other, one private owned prison to another. Is that the slave trade? So I think we need to think beyond the private actor. We need to think beyond ownership, as in how we've defined property, and begin to think about control and power and extraction of value as part of modern day enslavement.
Thank you, Dean Bravo. With your reference to the 13th Amendment, it reminds me of a wonderful paper, actually, that one of my human rights students at Howard wrote years ago, where she actually went back and looked at the history of the drafting of the 13th Amendment. And she found some language that showed that one of the authors who contributed to the amendment from Virginia that there was some language that clearly showed that he understood that creating this exception to the 13th Amendment was an attempt, right, to really to provide for continued use of of the use of the labor of African descended individuals. So it was not by accident. And of course,
Not by accident. And also replicated in international instruments too, though.
Absolutely.
And so, yeah, so and speaking about the re-enslavement of African Americans after the Civil War and Reconstruction, the 13th Amendment, that double-edged sword, that was a crucial part of setting up the convict leasing systems that led to re-enslavement.
Absolutely. And as you noted, the language of the 13th Amendment is almost identically contained in the ICCPR. So we see how this tradition can also be reflected in international instruments. I'd like to turn to Dr. Babington-Ashaye, if you'd like to reflect on this question or any other topic that we've raised thus far.
Thank you. So for me, when we reflect on the centennial of the 1926 Slavery Convention, of course, the striking reality is that slavery has not disappeared. It's evolved. We see it in armed conflict, migration routes, forced labor systems, and the other examples that Patty and Karen have also noted. For me, I've done a lot of work in the context of terrorism by non-state actors, and there the research clearly shows that groups such as Boko Haram, ISIS, Al-Shabaab, they exercise powers of ownership over the women and girls who are abducted, forced into sexual slavery, forced into forced marriages, and other forms of servitude. So we're seeing different ways in which the modern manifestations of slavery, are existent. And so while these manifestations may not have been conceived by the drafters of the 1926 convention at the time, they nonetheless implicate the same core prohibitions. I wanted to mention something connected to what Karen had said earlier about the enslaved people allegedly in quotes, liberated from slave ships. A great book that goes in this, and I'm going to put it in the chat as well, is The Bonds of Freedom by Jake Richard. And he talks about the long fight for freedom of African captives that were rescued from the illegal slave trade only to be forced back into bondage in various ways. So I'll put that in the chat too.
Thank you so much, Dr. Babington-Ashaye. I'd like to take this moment to now turn to our viewers and to encourage you to enter the proverbial chat and to use the Q&A button to include your questions. And we already have a couple. So I'd like to first raise a question for our entire panel. Anyone that would like to take this question may answer. This is from our wonderful and dear colleague on BASIL, Gabe McDougall. The question is, today there has been a civil society movement to refer to the transatlantic trade using the term trafficking. Is that accurate or helpful to our understanding of the events and the legal implications thereof? Perhaps Professor Sellers, as this has been a topic of your scholarship.
Right. Thank you very much. Thank you, Gabe, for the question. And I invite Dean Bravo also to join in. In my point of view, the misunderstanding that trafficking is a legal regime and the slave trade is a different legal regime has really caused too much confusion and conflation. I want to point out, and I was very happy to see Dean Bravo note that the trafficking conventions have a different origin, and that's why they were called white slavery in the beginning. They were worried about the movement of white women and girls into illicit situations that were sexual. They weren't worried about that with Black women. But they do, in some ways, resemble each other enough that taking over trafficking or making it take over slave trade has reduced the slave trade. Sorry, please continue.
Dean Bravo, please.
Yes, I'll piggyback on that because I've tried to wrestle with this in a number of my articles, the question of why did I have really a negative reaction when I saw that movement toward what I thought was diminishing the power of the transatlantic slave trade and slavery and its foundational impact on the modern world we live in. In fact, I might say we live in the world that the transatlantic slave trade made. And human trafficking is a horrible form of exploitation that is continuing, and it has some of the elements, but I think there are foundational differences with the transatlantic slave trade. I think to do with the way in which the transatlantic slave trade and slavery were essential to the creation of the Industrial Revolution, were essential to the expansion of European powers throughout the world, the non-white world, but also essential to the establishment of a global racial hierarchy, which was then enshrined in racial scientific literature, which was accepted norms that we still are dealing with today. And so to attempt to subsume transatlantic slavery and the transatlantic slave trade will lead to a lack of true understanding of what we came from, why we are as we are as a world now, to be better able to deal with the challenges of modern forms of slavery. We've got to understand the ongoing impact of the transatlantic slave trade and slavery in order to address these additional violations of human rights they're learning things. They've learned things from the transatlantic slave trade, and they're certainly operating within a regime where we have internationally addressed slavery that looks like the transatlantic slave trade, and we need additional instruments. Abolition is not enough, is what I usually say. Abolition is the start, because if there are not sufficient instruments in place, and if they do not address the incentive structures of power, then you're just going to have a mutation of exploitation.
Thank you very much, Dean Bravo and Professor Sellers, and Dean Bravo. That historical context, I think, is quite important for understanding terms that we have all seen in domestic and international law, but actually understanding the derivation of those distinctions. So thank you for that. We have some wonderful additional questions in our Q&A, so I'd like to turn to a question now from one of my current human rights students. So the question is, when advocating in an abolitionist approach, how does the current legislation and literature engage the agency of the enslaved and the ownership rights of the slaveholder, in quotes, when formulating the rights of the enslaved under different forms of slavery? How may one advocate for the dignity of the victimized within the context of restitution and reparation, not using the logics that motivated the harm? And I'll turn to anyone on the panel that would like to engage that question. Perhaps Dr. Babington-Ashaye, as you did mention some of the efforts at reparation, this would be a great question for you.
Sure. Thank you for the question. On the topic of reparations restitution, I would say the key is to avoid reproducing the very logics that justified enslavement. So the logics of commodification, the valuation of bodies, and very transactional thinking. So rather than framing it as compensation for property lost, which of course was what the, because it hasn't been mentioned today, but as hopefully people are fully aware, that the slaveholders actually got reparations, and they got reparations for property lost. So now, as we are discussing reparations for those who were for the enslavement and slavery, it has to be grounded in the restoration of dignity, recognition of the historical, but also the ongoing harm. So recognizing the connections and the repair of structural inequalities that are created by slavery, and also focus on empowerment of communities that have been impacted and over the centuries in which this occurred. One topic that I've been exploring that I think also works well in how we look at the issue of reparations is addressing narrative justice, or also another look at the narrative injustices that were done as well, by acknowledging the various narratives that facilitated the slave trade and enslavement, and recognizing the ongoing harms of these narratives and how they impact the ability of people of African descent to fully actualize all their rights to self-development in a global order, world order that's shaped by negative narratives and structures. So by looking at it, I think holistically, that's one way I would say to be able to address it. And this is also why the work of CARICOM and the African Union and other reparatory justice movements are very important, because they're not framing reparations just as this market-based calculation. The economics of it is important, but also considering a more transformative approach that is focused on dignity.
Thank you very much, Dr. Babington-Ashaye. We have time for one more question from our Q&A. So I will bring that in to the mix. Actually, we have two more questions. I will share both, and then I'll allow our panelists to respond to either. So the first question is, what have human rights leaders and advocates done to entangle modern day enslavement, such as through prisons and jails, from a country's economic stability? The example given is that in the United States and other countries, there has been an effort at the use of covert slavery through prisons and jails, largely because of the economic incentives that investors receive, such as private prisons in America. The second question is, how can young litigators, well, why don't we stick with this initial question? Because I think we have just enough time for that one. So does anyone want to comment on efforts that can be undertaken, I suppose, domestically and at the international level to deal with modern forms of enslavement, such as the use of prison labor?
There are international instruments dealing with or addressing prison labor. Think even of the WTO agreement, there's a provision there about the trade in goods produced through prison labor. I think where we have the difficulty is just the power of that exception language which is in our Constitution, 13th Amendment, and also replicated internationally. So it gives so much power on the domestic level. I think where one could address is really fighting against that language. I think we, without articulating it, tend to see the state as the good actor, right? It is the state that creates international law. So by default, it's the good actor, and therefore having this language with the exception, you don't expect it to be used, to be violated, but it is. And so going down this track, you think about and you have to question the nature of the state and the state's obligations to its population, and whether and how there are instruments and mechanisms that allow that challenge. I mean, private groups do try to do advocacy on behalf of people who are convicted and imprisoned, but it is really difficult even within our context. But in other countries, a system of imprisonment could be, let's say, more humane, shorter, doesn't include prison labor, includes rehabilitation. And so each domestic situation has to be addressed by domestic advocates. But I do think the fact that our international definition includes this huge exceptions has an impact. I hope I've answered the question.
Yeah, absolutely. Thank you, Dean Bravo. Professor Sellers.
Yes, if I could say briefly and without coughing, I think that we forget under the two conventions, the 26th and 56th Convention, that they can be used at the International Court of Justice against a state. When we look at some of the domestic labor that's done in the Middle East, and where there have been claims of different systems that are basically slavery systems in addition to the prisons, we might want to start reframing that to where the state not only is involved, but regulates it. And under the slavery conventions, you need not have a benefit. There's no requirement that you have to show an economic benefit for the slavery, the slave trade to have taken place.
Thank you very much. I think that's an important aspect to remember, is the ability of states to utilize the ICJ as a mechanism for addressing violations under the 1926 and 1956 conventions. We are coming to the end of our time, so I'd like to, as a final question, I will pose a brief question, but also I will invite our panelists to share any final reflection that they would choose. Dr. Babington-Ashaye did briefly mention additional advancements within the ASP, and I believe the UN as well, on efforts to enumerate the slave trade as an international crime, both within the context of the crime against humanity and as a war crime within the context of the Rome Treaty. I'd be curious if Professor Sellers or Dr. Babington-Ashaye would like to share anything additional about those current efforts, which our ASIL resolution was designed to help inform. And then finally, any closing thoughts that our panelists would like to share. So I invite you now to share final thoughts.
So Patty, do you want to take on any updates?
Look, I'll just take a very brief update. And I think as Dr. Babington-Ashaye has mentioned, that Ghana is bringing forward a resolution this week to the General Assembly. In December, the Assembly State Party should vote on amending the Rome Statute. And in the next 3 years, advocacy is needed for the Crimes Against Humanity Convention to include the slave trade.
Thank you very much. And additionally, any final thoughts from Dean Bravo or Dr. Babington-Ashaye as we close out?
My final thoughts are, it's been a long road, and we will be on this road for a while. There's a reason why my project is called Slavery Past, Present, and Future. Maybe I'm being a pessimist, but the idea that there's so much that we need to do in order to address these types of exploitations that fall within the definition of slavery and enslavement. And so having the opportunity to converse with Professor Sellers and Dr. Babington-Ashaye on this very important topic has been a great opportunity.
Thank you so much, Dean Bravo. And Dr. Babington-Ashaye.
Yeah, my final comments. I mean, it's been a huge honor to be part of this discussion. I would say that as we work towards having the enumeration in the Rome Statute, the Crimes Against Humanity Treaty, we need to also, the international community, when I say we, I mean the international community, must treat this not only as a crime and not, when hopefully we finally get, those enumerations listed, not just to see that, oh, the success, we got that, but to then focus on tackling the structural systems that require state coordination, a coordinated state action, I mean, both in terms of internationally and also domestically, thinking about ways that the state needs to address the actions of private actors, financial flows that are facilitating modern slavery, ensuring also that states cannot hide behind any jurisdictional or territorial limitations when people are being sold or transported or exploited across the various borders. And so just not looking at, the legal black letter law once we get it as an achievement, but thinking beyond that, well, how do we address this in policy and actually break down the structural systems that have been established?
Wonderful. Well, please join me, all of you who are watching on the screen. Please join me in thanking our really phenomenal panel for their wonderful reflections at this centennial moment. And with that, we will close. Thank you.